There are not going to be any bring forwards today because, in a sense, this talk, which I'm going to whip through fairly quickly, is exactly that. And I want to leave as much time for Brian Dartnell-Levier, who's joining us at 11:30, and from whom all of you would like a job. So try and do that properly. So ethics in games. This is, part D is the only talk that's one talk, or the only section of the course that's one talk. Conciliation. How do we bring this together? So I'm going to try and bring it together is really playing off of where the tension was at the beginning of the course. And that is, what's the essence of a video game? And what is a game? What is a video game? And what does that tell us about how we should treat it in law? Any questions to this point in the course? Good. All right. So 2 cases that we have talked about, which seemingly have nothing whatsoever to do with each other. We spent a lot of time on Davidson, not quite as much time on Brown. Brown is also known as Schwarzenegger, and it's the case of California statute that tried to regularize and regulate video games, went to the US Supreme Court. And Davidson and Associates is the Blizzard case that established, in the minds of the US Court of Appeal, a circuit that contracts took precedent over copyright law. So the Blizzard case, also known as BNETD, the argument was that Blizzard's EULAs should be preempted by copyright law. The court held the opposite. The EULA preempted copyright law. Schwarzenegger tried to define a violent video game. A video game in which the range of options available to a player includes killing, maiming, dismembering, or sexually assaulting an image of a human being. Yes, we can discuss, are zombies human beings, and et cetera, et cetera. So there's all of that. And there's a test. And very important to understand that Schwarzenegger is not the first case of its kind. It's like the 15th case of its kind. So the drafters had ample opportunity and lots of cases to study, to try and draft in as particular a way as possible to allow the statute to survive. This wasn't like a first try. So, US Supreme Court on a number of subjects. I'm just going to whip through. So the key one, of course, is the majority of the court says correlation established, not causation, not the same thing. We need causation to put aside First Amendment freedom of expression concerns.
Sorry, I didn't actually have a chance to read this case, but it's essentially about infringement of their version of like a charter interest, and they have something like an Oakes test where they're looking for justification, and that's why they're trying to support why they're infringing it, or why does it matter if they have studies of correlation versus causation?
So, excellent question. Let me deal with it this way. The First Amendment of the United States defines, first of all, it uses the word speech, not expression, as we do. And secondly, if you read the wording, it seems very absolute. You'll pass no law that abridges freedom of speech. The American, what arose in American jurisprudence to deal with that, to create some sort of balancing test, they had very few places they could go because of the wording of the First Amendment. So there's no balancing test. There's no Oakes test, and there's not even a Section 1. There's no Section 1 test that inspired Oakes. So what ended up happening was this tension around what is speech. So things that offended, for example, in the 60s and early 70s, burning a U.S. flag was, for a time, defined as not speech. And therefore, if it's not speech, it's not protected as speech. So they categorize things in that way, whereas the Canadian approach, with great respect, is more natural, which is we protect freedom of expression. We're not going to get into a big haggle about what's expression and what isn't. There are a few cases. There's a Manitoba Court of Appeal case, Mr. Justice Twaddle in a case of a bar and strippers defining that kind of dancing as not expressive, which I think says more about Manitoba than it says about anything else, but we won't go there. But aside from that one attempt at a Court of Appeal level, we've been very inclusive in Canada in terms of what's expression, and then we go to the balancing test of necessity in a free and democratic society. I happen to like our test, but I'm Canadian, so hopefully that answers the question. And then, very interesting aside that goes to what is the essence of the video game. And this is the U.S. Supreme Court on comparative literature. Grimm's fairy tales are very grim. As the line of one of the justices was. Cinderella. There's lots of violence. There's lots of violence in great literature all over the place. And it's part of the history and part of the history of what children have always seen. So it's a sort of a very interesting take. And why it's relevant is because it at least starts to imply the interactive nature of even reading and the fantasy nature. And that starts taking us, to some extent, within notions of the magic circle. But the court goes further and actually divides on interactivity itself. Justice Scalia doesn't think that interactivity makes a very big difference in how they should look at the violent element. And I'm just guessing, not to get behind his words, that he's thinking, gee, if you're a really active reader or a really active movie watcher, that may not be interactive in the purest sense, but it is interactive in the sense that we talked about earlier in the course with Ken, of the user or the reader immersing themselves in a very real way. So that connection. And then Justice Alito, suggesting that, you know what, the experience of playing a video game may be quite different from reading a book. So, should it make a difference? Shouldn't it? Is this just another example, if you say it's different, is this another example of the wrong turn we talked about in the context of the patent case, where the judge said, no, the prior art wasn't the computer at MIT, but rather this is a television device, and there was no prior art, therefore there was a patent infringement. So, and my conclusion is, whether you accept it or not, that was a wrong turn as things evolved. So is it a wrong turn or a correct turn to say video games are different from books because they're interactive? Really important question that we don't know the answer to, and the US Supreme Court is split on. Any quick thoughts?
Yeah, the American approach on freedom of speech has been to divide up into, as you mentioned, various categories, so that you get different levels of protection depending on what type of speech it is. And a lot of the argument then rolls around as to whether or not, what the effect might well be. And the evidence that they bring forward for that is quite often almost anecdotal, but what they're looking at is things like, how do you justify if you say that there is no effect, no cause and effect on the first shooter games, with the use by the U.S. military of a variety of shooter simulations, which may or may not, in fact, desensitize the soldier in the field and allow them to do a variety of different things. So on one hand, if you're arguing that these are not very effective, then why is the U.S. government spending so much money to put so many of their military through them? On the other hand, if you argue that they are effective, why is it that you then have this difficulty establishing the causal relationship? And I think it's one of the reasons why the Canadian approach has used as its kind of wiggle room the justification element of
And I like the Canadian approach for that reason, and I'm going to go to another question, and then I want to talk a little bit about Newtown, because some interesting developments this week on that speak to your point.
Okay, so this is kind of interesting because I'm writing a paper on this exact issue. I think the first thing to do is to clear up a little bit of the discussion about what the American approach is. And so basically,
Can you hit the mic, because what you're saying is important?
So to clear up a little bit about what the American approach is, the way I look at it, they very much do have a balancing test. So they start with the idea that the statute restricts speech based on its content. So from there, they take what's called a strict scrutiny approach to the
There's strict scrutiny or not, which is their version of balance. Correct. Please go on.
And so in the strict scrutiny approach, it's a test, right? And if you don't pass the test, the statutes, it's invalid. And the components of the test are remarkably similar, I think, to our Oaths test. So you've got to prove a compelling governmental objective, which is obviously the first part of ours, and then you've got to prove that the statute is narrowly tailored enough that it doesn't, unduly restrict the freedoms that we have, which is, the way I look at it, the proportionality section of, our Oaths test. And so the interactivity argument is particularly interesting because in Brown, California was, one of the arguments that they threw out there was, of course, video games are something completely different because they're so interactive. And I think the court gets criticized, or it has gotten criticized a lot because Scalia in particular, he just looks at current video games, past video games, and the industry is like 30 years old. The next 10 years are going to be completely different than what we've seen. So, I think that's something that's going to be very much at the forefront of future litigation.
No, I think you put your finger on it, and I should be clear and hopefully not defensive in saying, the way the U.S. gets to an Oakes-like test is kind of strained because it's completely defined by the courts, whereas at least there is a pretty direct line between Section 1 and our wording, our constitutional wording, and Oakes.
Just a quick question to follow up on that, and I assume you know a lot about this. So in the context of Brown, my understanding for strict scrutiny, when a statute, like the purpose of the statute expressly restricts speech, such as in this case, isn't the test for strict scrutiny that it has to be a clear present danger, or am I confusing that?
So the words "a clear and present danger," I think, off the top of my head, I think that comes out of one of those seminal, First Amendment cases. But in the cases that I've looked at, it's not always there. It's not like a very, very clear part of the test. The words that I saw in every case was a compelling governmental objective.
Yes,
so,
I totally agree with that interpretation. I think that's exactly right. You don't see clear. You see clear and present danger sometimes, but it's not the overwhelming test that comes up time and again. So just a very brief note that's timely. Did anyone see the report that was issued, and I want to deal with this seriously, around the shooter in the Newtown, Connecticut school murders this week? So a report was issued, and again, it's a difficult thing not to. So the shooter did play violent video games, and it also appeared that his favored video game and the video game that he was most obsessed with was Dance Dance Revolution. So you get to this place of when you're dealing with correlation and dealing with causality, that's very difficult. And because it's plainly absurd to say that Dance Dance Revolution causes someone to commit such a horrific act. Yet, it may seem more logical to go the other way, but is it? And it just illustrates the paradox. And I take you back to the quote around the 15-year-old who committed suicide and whose mother sued that we went through earlier in the course, where the court said, look, sometimes these things are unknowable. So, sorry to go over here, but I want to play you two things. So first, the BNETD Davidson case. I'm going to, and hopefully, how do I get the volume up?
May it please the court. Although the parties have addressed many specific issues in their briefs, this appeal is really about one overarching.
So I don't know if you can hear this. I'm going to get us to about 32 minutes. I should have tested this out in advance.
Okay. Spend this kind of resources to invent new games, knowing that they'd be pirated, but in some way we would still be able to recover by people wanting authentic games so they could play online, advertising, and so forth. This case does not involve new creation. There may be a case that does. This isn't it.
Okay. So I take you back, and I wanted you to just hear the tone, and I apologize that the volume's not quite what it should be. This is the counsel at the Court of Appeal representing Blizzard. As you'll recall, this was a case of a community group getting together, reverse engineering Blizzard's multiplayer tool, which wasn't working all that well, and distributing it for free. And this is the case that established the end-user license agreement over the freedom to reverse engineer in the U.S. copyright law. And what you heard was Blizzard's lawyer saying, this case does not involve new creation. There may be a case that does. This isn't it. So don't worry about freedom of expression. Don't worry about rights to create. This is just a tool and a bunch of hackers, and they weren't doing anything creative. Now let me be a little careful here. Saying that to a group of judges who probably didn't know a whole lot about writing code in 2005, maybe that lawyer didn't really understand, really did believe that writing code for an application that, like BNETD, was not creative. I guess we have no choice but to give him the benefit of the doubt. But it seems a very strained argument today. But it obviously was less strained in 2005. So now, hopefully this will come out a little louder. I'll try and play this right from the beginning.
We'll hear argument first this morning in case 08-1448, Schwarzenegger versus Entertainment Merchants Association. Mr. Morrazini.
Mr. Chief Justice, and may it please the Court. The California law at issue today before this Court differs from the New York law at issue in Ginsburg in only one respect. Where New York was concerned with minors' access to harmful sexual material outside the guidance of a parent, California is no less concerned with a minor's access to the deviant level of violence that is presented in a certain category of video games that can be no less harmful to the development of minors. When this Court in Ginsburg crafted a rule of law that permits states to regulate a minor's access to such material outside the presence of a parent, it did so for two fundamental reasons that are equally applicable this morning in this case. First, this rule permits parents' claim to authority in their own household to direct the upbringing and the development of their children. And secondly, this rule promotes the state's independent interest in helping parents protect the well-being of children in those instances when parents cannot be present. So this morning, California asked this Court to adopt a rule of law that permits states to restrict minors' ability to purchase deviant, violent video games that the legislature has determined can be harmful to the development.
What's a deviant, violent video game as opposed to a normal violent video game?
Yes, Your Honor. Deviant would be departing from established norms.
There are established norms of violence?
Well, I think if we look back...
I mean, some of the Grimm's fairy tales are quite grim, to tell you the truth.
Agreed, Your Honor. But the level of violence...
Are they okay? You going to ban them too?
Not at all, Your Honor.
What's the difference? I mean, if you are supposing a category of violent materials dangerous to children, then how do you cut it off with video games? What about films? What about comic books? Grimm's fairy tales? Why are video games special? Or does your principle extend to all deviant, violent materials in whatever form?
No, Your Honor. That's why I believe California incorporated the three answers.
All right. So I'll leave it at that. The audio is in the materials. It's in the syllabus. It'll be in the slides. Well, actually, it won't be in the slides, but I'll put a link that you can go through because it's way too heavy in the slides. I can never get them up on the website. Why are video games special? So we're back to what is the essence of a video game. And where should they be special and where shouldn't they? So what are the common denominators in that light? What are the common denominators between these two cases? And really, the common denominator that I can identify is creativity, concerns about creativity. In Schwarzenegger, there's this concern about actually the creativity of children who read and depriving them of literature and material that they sharpen their mind against, even if that material is questionable. And in Davidson, oh, no, that's not creative. Doing that mod is not creative, because if it was creative, it would be protected. So the common denominator, I tentatively suggest, the first one, is protecting creativity, which is definitely a meme of the course, and definitely at the essence of video games. And not just the developer's creativity, but the user's creativity in a game context, because the user, the player, is increasingly a form of developer as well. This goes directly to the chilling issue. We don't want, isn't that a beautiful picture of a storm? We don't want chill, because chill affects our creativity, affects the humanness of it. So then, for the rest of the next 10 minutes, I'm going to go very quickly, just using mods as an example, because it's kind of a core example, how this plays out. There's not a lot here that's new, but the narrative aspect to how it's tied together is. So the starting place, and I've already seen this in some draft papers, is, the digital world seems to have confused the law. And we obviously see this around literalism in the Aaron Schwartz case. Uh-oh. Oh, this is a fancy slide, sorry. We are disappointed by this. Should we be? And is it perhaps the effect of an inevitable cause? And so again, I've developed this a little bit in the course of our time together, and that's the notion that concepts of law and justice do not shape communications technologies nearly as much as they are shaped by them. So there is an inevitable delay. We will never get, the law will never get ahead of the curve here. It can't, because the law, in fact, is a product of how we communicate, and technology changes how we communicate, so we just have to play through the process. And if you want a deeper lesson to that, it is, and this will seem a little more political, that being a progressive lawyer, pushing for advancement in the law is actually, and I think if you look at the history of jurisprudence, the correct decision. Because there is inevitable progress and evolution to the law, whether we like to acknowledge it or not. And that just goes to, I'm not going to spend much time on this slide, but I'm working on this. And this is just a way of illustrating that justice changed as our instruments of communicating changed. And I'm still working one day soon, hopefully, it'll be a paper. The next piece that we've talked about is that the cases, if you really parse them out, at the end of the day, don't neither allow nor prohibit creative modding. The toughest case is iRacing. It's also a lower court and very decision and very particular set of facts. And then again, Davidson, this case does not involve new creation. So that leads to the possibility that we can evolve a single standard for creators as users and users as creators. And we've talked about this a lot. But we can only do it if we evolve certain principles. And we have to agree on what those principles are, so I'm going to suggest a few. Ethics before law. Ethics has to inform the law, and this is, if we accept, and if you accept my suggestion that the law can never catch up on communications technologies, then it's even more important to delve a little deeper into ethical principles in order to inform the law, because it has to come from somewhere. It's not simply going to come from old wine into new bottles. Then, sort of our favorite, everything is connected. Those of you who watched the Springsteen keynote before class got some of this, but there are the key moments if you want to go back. And then just a really interesting piece that just came out. Again, pure academic research. I don't know what to make of this, but it really goes to this notion of, what is a video game and what is the essence of it. Playing computer games together makes brains feel and think alike. Now, maybe that is perhaps the singularly least surprising result, or the most surprising. But it really goes to the principle of connectivity in an additional way over all the other cool quotes and Springsteen evolving an animal song into some of his biggest hits. That to me was a really profound moment in that video, to actually watch him turn their song into his song, because it speaks to connectivity and the fact that we all get it from somewhere. And those of you who like art criticism, I've pulled out this fascinating quote because I had a great debate with one of my friends who's an artist on this subject, and he referred me to a particular book. And this is a book that takes on the artist as being a narcissist. And so for video game purposes, I want you to remove artist and put in video game developer or distributor. And this is a rejection of the unimportance of the audience. It says the audience is as important as the artist, which really speaks to, player, user as developer, and kind of the mixed roles. And I'll do a little bit on that in a minute. More than ever, the narcissistic interests of those who make art count for more than the human needs of those who desire and supposedly benefit from it. And how much they benefit from it is the contemporary question about art. So you can read the whole piece, but it's a fascinating take. Which leads to Again, I'm starting to go really far afield, but Derek Parfit is probably acknowledged as the world's greatest currently working philosopher. He's at Oxford. And I can't do justice to how he tries to evolve an ethical framework that has certainty that doesn't involve religion. But he does it, and he does it very effectively. But to do that, he really looks at, and so do other philosophers, how do you measure good? And you measure good for all. And that takes you to a really interesting place where, if you looked at it philosophically, and if you asked, I think, some of these philosophers, including Parfit, what do you make of modding, and what do you make of user-generated content? They might say, because far be it from me to put words in their mouth, well, tell me how much modding there is as compared. So tell me how many digital bits were in the game and how many digital bits are made available by modders to the community. Are there more digital bits available to the community than were in the original game? Then arguably that's one way. It doesn't deal with quality issues and other things of saying, well, the greatest benefit is coming from the community. In any event, this approach, a more philosophical approach, really distorts the issues around intellectual property. Which then takes you to, you've seen this slide about 5 times, is creativity more important than property? And then the possibility that we're just bartering with each other if we're in fact all creators. I, in some way, make available this course online, and hopefully others make available stuff to me. And in fact, they do. Because I can go to iTunes U and watch all sorts of stuff for free. Taking us back to what we talked about earlier, prior restraints is a problem. And that contracts, EULAs in particular, in terms of service, have become a particular modality of prior restraint that I'm not sure anybody really expected. I certainly didn't expect it in 2005 when I wrote this. I mean, it just was barely on my radar. And when we're talking about restraints, the map of restraints that you've seen, and the notion that where we have restraints, they in fact distort the creative process. So, if you're relatively sanguine where this goes, what are the ways, the methods possible? And this applies to mods, it applies to all user-generated content in all contexts, I think, moving forward. Well, we can move away from the video part into the game part and say, look, no protection for games. Video games are games, therefore they don't have to worry about it. Not likely to happen. We can raise the thresholds for IP protection. We can combine the two. And this seems to me somewhat realistic given the things we've talked about in the course. Oh, sorry, wrong slide. Please.
I argue, and I do in my paper, that Canada has chosen method 2, or method B, that we've certain exceptions, like the non-commercial user-generated content provision that was included in 2012, and saying, well, you can have IP protection insofar as you have moral rights, you can have copyright protection insofar as you don't want distortions of the game, but if there's a non-commercial modification out there, then that has IP protection subsisting in itself. And so long as it isn't taking your cut of the economic pie, you have no claim against it.
I think you're exactly right. And I'm going to actually get there. I'm actually grateful you're telling me that that's where you're going in your paper, so so I know where it comes from. But yes, when I talk about A and B combined, I'm actually setting you up for the Supreme Court of Canada. But you've got the thesis down. So this takes us, if you combine the two sort of roughly, you say it's not the game, it's not the interactivity, also takes us back to the US Supreme Court, but it's the art that attracts copyright protection. And that's fairly limited. Another argument, we won't go through Sony again, but that this is all in a digital world, fair use is context shifting. Sony was about time shifting. When we look at the digital world, we're just moving digital bits around into different contexts, and time shifting should grow into context shifting. I hate when that happens. There we go. Getting better. Which takes us back to the right to mod and create, which then takes us to the Supreme Court of Canada, who, in a sense, have used all of these things in particular ways. And to me, I've said this before, but it really started with the right to link in Crooks and Newton, because that is a profound right. That is context shifting. Nothing could be a better statement of context shifting. And a right to use. And then to be protected for it. But then that, to me, grew into the pentology. But the pentology, the Supreme Court of Canada's approach, ends up perhaps being about all things. Certainly, as was just noted, using content makes you a creator because below a certain threshold, the Supreme Court of Canada has said we're going to look the other way. What we haven't seen, and this, I've put this in round brackets, is I'm not sure we've seen the other side of the shoe drop. Supreme Court of Canada doesn't just do one thing. There's often something else that drops. And we haven't yet seen a lot of elaboration on what individual rights and what the rights and responsibilities of the individual user are yet. And I think we're going to see that case evolve in the next 5 years. I think if you read the pentology, it's all about the developers, the distributors, and reining them in. But it would strike me as quite unlike a court to not focus at some point on that issue. So, I'm going to try to replicate this slide. Anyways. I've given you these quotes before. Fair dealing is a user's right. So therefore, if you move the user up, the rights of the distributor become higher. What are they? As you pointed out, they're more in the commercial realm. And if you look at non-commercial user-generated content provision of the Act, it becomes really, really clear. Section D, the use does not, for it to be a legitimate use, it does not have a substantial adverse effect, financial or otherwise, on the exploitation or potential exploitation of the existing work. So it'll be very interesting to see how that is interpreted, because the Supreme Court of Canada has given us some sense, of where they are. And so if they apply the spirit of the pentology to 2921, we might find that there's quite a lot of users' rights and quite a lot of modding rights. Don't forget about moral rights in all of this. It goes down a very consistent path with the pentology. Nobody's written that paper yet. Maybe somebody here will, maybe someone somewhere else will. But what the Supreme Court of Canada has done with the pentology almost mirrors the notion of moral rights, that within a certain sphere, it's non-commercial. Because moral rights are not commercial rights, and that's the key to them. So within, there's the non-commercial sphere, where users and creators have certain non-commercial rights, which is why a couple of slides ago I said that's the other shoe to drop. What are the individual responsibilities to the authors in the non-commercial realm? And then you get the commercial realm above that. So these are probably trite conclusions, but if you accept that we should not expect the law to have all answers in a fully canned way to new communications technologies, we have to change our thinking somewhat, and hopefully this course has helped you do that. And don't forget about Boyden. Don't forget that you as the gamer are part of the system, and it is the system that is uncopyrightable. And this slide has been distorted by the AV. But in this day and age of expression being so automatic, it makes sense that users have rights, because we are so overwhelmed by other people's expression. And if we hung on to every bit of our expression, if you could imagine, if we hung on as every bit of our expression as our property, what a crazy and unworkable world of communication or non-communication it would be. Which takes us back to understanding the evolution of IP really is as part of the democratization of thought rather than a property right. Bunch of articles, because I always give you a bunch of articles, and number 6 is the key. I probably should have yellowed that out and made it a little more prominent. A couple of very, very final thoughts. think about the conundrum of user content in the context of colonialism a little bit. And it may start making a little bit more sense. Intellectual property has certainly been looked at as a kind of neo-colonialism for a variety of reasons. And I think the metaphor actually helps when you think about user-generated content, when you think about mods, when you think about everything that's coming across the transom at you and how you might or might not want to use it and transform it. Which takes us really kind of to the completion of the circle around, and the completely obvious completion of the circle, if you accept that we can't expect the law to know fully formed what to do with communications technology. It is going to come down to the courts. This is a wonderful piece by Rebecca Tushnet from Georgetown. The future of fair use as a formal doctrine in the United States depends on whether judges act like bad reviewers on Amazon.com or whether they behave differently in interpreting challenged works than they do in almost every other aspect of judging. That's a pretty pessimistic view. I have a slightly more optimistic view in the introduction I wrote to the current issue of the UBC Law Journal. So you'll have to decide for yourself. I said at the beginning of the course that what's important about video game law, which seems like such a trite subject, is that games really represent the cutting edge of the digital world. And they still do so in terms of freedom of speech, expression, copyright, IP, and contracts. And games, to me, still remain the best lens through which to look at the advancements of digital technology, no matter what the sphere. And if there's one thing I hope that I've at least established in your mind throughout the course, is that this is an important subject, not because video games are hugely important, but because for a variety of reasons, they attracted the money, the technology, the experimentation that really tests out and continues to test out our boundaries, and therefore, from a legal perspective, are particularly interesting. I just want to briefly mention one of your former colleagues who did the original research on this book, and therefore I always owe him a debt of gratitude. And he passed away in a tragic sporting accident. He was a great athlete, and we don't really know what happened. So thank you. I always learn more from you guys than I learn from anyone else. So I appreciate your effort, and we'll have a final goodbye after Mr. Dartnell takes us through his presentation, and please stay in touch. Great way of ending the course. Thank you all. You've been a great class. I look forward to your papers. I will keep Wednesdays as kind of office hours and 469 to the end of the semester. If you need anything, email. Hopefully I've been back to everybody who does want to talk to me. And now I will have a little bit more time if people are sending draft papers, as some of you are. So appreciate you all very much. Sasa, please.
Sorry, do you want us to put our exam code or our name on the paper? I know some files are kind of
I am distinctly not particular. both is good. Belt and suspenders. We're in law school, so both is really useful. If you're concerned about me marking blind, I'm happy not to have names and just do the codes. So it's all good either way. I think different people have done different things. I have figured out enough of the system that I think it's okay. I can muddle through. All right. Thank you very much. Good luck with all your stuff.